right, guys. Another one that I have been intending to record for quite some time, but current events have sped up that timetable a little bit. My name's Hawk. Thank you for watching this video. Today we're going to talk about martial law, its meaning, some history behind it in the United States, and whether or not the President of the United States can unilaterally declare martial law. Spoiler alert, no, he cannot. But that doesn't mean that he can behave as though he has, and that he can order the military to behave as though he has, and then just let it make its way through the courts, I guess. My name's Hawk. I've been a trial attorney for 26 years. I live in the Bay Area, and I like to talk about news, politics, and the law. If you like this video, please click like, leave a comment, and subscribe to my page, which is free to do. So I'd been doing a bunch of research on this, and I found an article that sums all of this up nicely, and I'm going to go through some of it because it's about a 30-page long article that I found on the website for the Brennan Center for Justice. It's an article written by a guy named Joseph Nunn, and it's been republished on their website, but it was first published on August 20th of 2020. The last time we had Trump in office and we were worried about whether or not he was going to declare martial law during the Black Lives Matter protests of that year, as well as COVID. His article is entitled Martial Law in the United States, Its Meaning, Its History, and Why the President Cannot Declare It. The concept has never been well understood. What should be clear, however, is that the president lacks the authority to declare it. So I think it's important that we have an understanding of this and what it is. But again, it's like even in the context. So today is Tuesday, June 10th. Last Saturday evening, President Trump, who is still a convicted felon, signed a memorandum instructing the Secretary of Defense, the Attorney General, and Secretary of Homeland Security to federalize 2,000 National Guard troops in California and deploy them in Los Angeles. Then last night, overnight, 700 Marines have been deployed from 29 Palms, to Los Angeles. And so now there are military boots on the ground in an American city. And that is illegal, barring the president invoking the Insurrection Act. And so relative to what we're going to talk about today with regard to martial law, President Trump is behaving right now as though he has invoked the Insurrection Act, but he has not. He has ordered active duty military into the streets of an American city. The only way that's legal is if he invokes the Insurrection Act, which he has not yet done. And so one of my overall points in this discussion is that he may very well start behaving as though he has declared martial law without actually doing it, despite the fact that he has absolutely no legal right to do so, given the Constitution and the current state of our federal statutory scheme. So let's start talking about what it is. Martial law, a term that generally refers to the displacement of civilian authorities by the military, can be and has been employed in the United States. Federal and state officials have declared martial law at least 68 times over the course of our nation's history. At the federal level, it hasn't happened since World War II. And at the state level, I don't think it's happened since the late 60s or the early 70s. Yet the concept has never been well understood. The Constitution does not mention martial law, and no act of Congress defines it. The Supreme Court has addressed it on only a handful of occasions, and the court's reasoning in these decisions is inconsistent and vague. The precedents are also old. The most recent one was decided almost 75 years ago, following World War II. So what is martial law? It has no established definition in U.S. law. and this article aims to clear up the confusion. To do so, this article draws on a bunch of sources: legal scholarship, Supreme Court decisions, and general principles of constitutional law. The article concludes, based on all of those things, that under current law, the president lacks any authority to declare martial law. Congress might be able to authorize a presidential declaration of martial law, but this has not been conclusively decided. State officials have much more leeway there. Outside of these general principles, there are many questions that simply cannot be answered given the sparse and confusing legal precedent. Moreover, although lacking authority to replace civilian authorities with federal troops, the president does have ample authority under current law to deploy troops to assist civilian law enforcement. But until Congress and state legislatures enact stricter and better defined limits, the exact scope of martial law will remain unsettled. And the president's ability to order domestic troop deployments short of martial law will be dangerously broad and undefined. In the United States, however, the military's domestic activities typically fall into one of three categories. First, the armed forces sometimes assist civilian authorities with non-law enforcement actions and activities, such as responding and supporting after a natural disaster like Hurricane Katrina in 2005. Second, and far less frequently, the military assists civilian authorities with law enforcement activities. For example, state and federal troops were deployed to help police suppress the 1992 Los Angeles riots in response to the not guilty verdict in the Rodney King trial. But George H.W. Bush, who was president at the time, specifically invoked the Insurrection Act in doing that to make it legal. Donald Trump has not done that this time. Third, on some occasions, the military has taken the place of the civilian government. This happened in Hawaii during World War II, following the attack on Pearl Harbor. Usually, but not always, the term martial law refers to a third category. It describes a power that, in an emergency, allows the military to push aside civilian authorities and exercise jurisdiction over the population of a particular area. Laws are enforced by soldiers rather than police, and policy decisions are made by military officers rather than elected officials. This is a dramatic departure from normal practice in the United States. A little bit. And martial law turns the relationship between the military and civilians on its head. The displacement of civilian government distinguishes it from other emergency powers, such as the suspension of the writ of habeas corpus. That's been in the news a lot lately as well. Suspending the writ allows the government to detain and hold individuals without charge, but does not imply any unusual role for the armed forces. While a declaration of martial law may be accompanied by a suspension of habeas corpus, they are distinct concepts. Martial law has been around since the 1530s in England during the reign of King Henry VIII. At that time and for centuries afterward, martial law generally referred to what is now called military law. The United States didn't even recognize martial law as an emergency power until the mid to early 1800s. Before that time, the idea of allowing military rule in an emergency was considered outrageous. As evidenced by the national reaction to the first declaration of martial law in the United States history. That was in December 1814, towards the end of the War of 1812. General Jackson led a small army in the defense of New Orleans against a much larger invading British force. As part of his defensive preparations, Jackson imposed martial law on New Orleans. He censored the press, enforced a curfew, and detained numerous civilians without charge. Moreover, he continued military rule for more than 2 months after his famous victory at the Battle of New Orleans had ended any real threat from the British. Jackson argued that his actions were justified because the government of New Orleans had ceased to function as a result of the impending British attack, leaving the military as the only body able to protect the city. In that situation, he claimed the military had the authority to do anything that was necessary to preserve New Orleans. At the time, pretty much everyone rejected Jackson's theory. In an 1815 court case coming out of that, the Louisiana Supreme Court described Jackson's conduct in New Orleans as trampling on the Constitution and the laws of our country. Overall, the consensus in 1815 was that martial law was simply another term for military law and that military jurisdiction could extend no further than the armed forces themselves. So the Supreme Court has never directly held that the federal government has the power to impose martial law ever. The United States has made extensive use of martial law during its history. During the Civil War, imposing martial law on border states like Missouri and Kentucky, where U.S. forces were battling Confederate insurgents. The Confederacy relied on it as well, heavily. The practice did not end with the Civil War. In the 90 years between the start of the Civil War and the end of World War II, martial law was declared at least 60 times in the United States. What had been manifestly unconstitutional in the eyes of the Louisiana Supreme Court in 1815 had become a relatively ordinary part of American life by the end of the 19th century. States have declared martial law far more often than the federal government, but the last time was somewhere in the late 60s, early 70s. State officials have sometimes declared martial law in response to violent unrest or natural disasters. Far more often, however, they have used martial law to break labor strikes on behalf of business interests. So, some things never change. The federal government has used martial law far less frequently than the states, imposing it only a few times since the end of Reconstruction following the Civil War. Generals have declared it far more often than the president, such as in 1920 when U.S. Army General Francis Marshall imposed martial law on Lexington, Kentucky, in an attempt to suppress a lynch mob from storming a courthouse. Most recently, the federal government, I mentioned Hawaii, and which initiated 3 years of absolute military rule of the Hawaiian Islands ending in 1944. And then it just kind of vanished. At the state level, martial law was last declared in 1963 in Maryland. But even as the power to declare martial law has not been used in decades, it still exists in the case law and the record books and remains poorly understood. Unless you speak to a Donald Trump voter. They know absolutely everything there is to know about martial law, and they can't wait for it. Notably, those are the same inbred, mouth-breathing, fart-huffing, MAGA dickhead chuds that fly the "Don't Tread on Me" Gadsden flag and see absolutely no irony in doing so. That's just because they're stupid. Part 2, can the president unilaterally declare martial law? Short answer is no. The Supreme Court has never explained the legal basis for martial law. It has implied that the federal government can declare martial law, but has never said so conclusively or under what circumstances. When discussing the possibility of federal martial law power, the court has never clearly indicated whether a president could unilaterally declare martial law or if Congress would first need to authorize it. And again, there's nothing about martial law in the Constitution, Article 1, 2, or 3. Looking only at the Supreme Court's martial law decisions, one can pick and choose from them to argue for or against almost anything. The case law is inconsistent and too sparse for a clear pattern in the court's reasoning to emerge. It's also old. The last martial law case dates to 1946 and predates many significant developments in U.S. constitutional law. So the precedents are not of much help. One very important case that doesn't mention it but kind of addresses this subject area. It's a case that we all learned about in law school, Youngstown Sheet Tube versus Sawyer. It's a 1952 Supreme Court case that held that Harry Truman could not seize United States steel mills to prevent a labor dispute from disrupting the nation's supply of steel during wartime. The decision has since become a doctrinal lodestar for assessing any exercise of power by the executive. And this was written 5 years ago, okay? But think about everything we're talking about in the context of what's going on today. Donald Trump, immigration, a lot of the other things that he's trying to do. Consider, for example, if the president were to declare martial law over the U.S. border with Mexico, deploying the army to enforce federal immigration laws and setting up military tribunals to prosecute alleged violators. In that hypothetical scenario, a federal court would likely apply the Youngstown case to decide whether or not the president had exceeded his executive authority. But the Youngstown case did not address a declaration of martial law. A concurring opinion briefly mentioned the concept, but noted that the Constitution's drafters made no provision for exercise of extraordinary executive authority because of a crisis. Furthermore, and I've discussed this quite a bit over the last few days, the Posse Comitatus Act creates a general rule that it is unlawful for federal military to engage in civilian law enforcement activities, even if they are merely supplementing rather than supplanting civilian authorities, except when doing so is expressly authorized by Congress. As it is generally understood, military or martial law necessarily involves military participation in civilian law enforcement. While there are a number of statutory exceptions to the Posse Comitatus Act, none of them authorizes a president to declare martial law, including the Insurrection Act. Therefore, a president's declaration of martial law would directly violate that act. The critical question then is how Congress allocates the powers related to domestic deployment of the military. And there's a discussion about those provisions within the Constitution. There's 3 of them. Because the Constitution does not give the president conclusive and preclusive authority over domestic use of the military, on the contrary, vests that power in the legislative branch, the president cannot act against Congress's wishes in this area. Oh, thank God, we will be saved. We'll be saved from Donald Trump declaring martial law by the current Congress. Wait, huh? What? Oh, yeah. No, I understand. Thanks for the reminder. We're fucked. It bears emphasizing that this conclusion is compelled partly by the Constitution and partly by federal law itself. It is possible that in the absence of the Posse Comitatus Act and other laws regulating military activity within the United States, the president could rely on some other executive power, but that is highly hypothetical and inconclusive. So, Donald Trump has deployed United States Marines to be boots on the ground inside Los Angeles County, active duty military functioning on U.S. soil against American civilians and citizens. The Posse Comitatus Act says that it's illegal for him to do that. The only exception to that is if a president declares or invokes the Insurrection Act. as George H.W. Bush did in 1992 in deploying active duty Marines to respond to the riots in Los Angeles following the Rodney King verdict. Donald Trump has not declared or invoked the Insurrection Act. He has only invoked 10 U.S.C. 12406, which is a code section that speaks to his federalization of National Guard troops. The only exception to the Posse Comitatus Act is the Insurrection Act. And rather than a single package of legislation, the Insurrection Act consists of a series of statutes that were enacted between 1792 and 1871. Those were later codified. I think it's 10 USC 250 through 10 USC 255 in that range. I know that 251, 2, 3, and 4 are part of that group. 3 of the Insurrection Act's provisions grant the president power to deploy troops domestically. 251 and 252 are straightforward and deal with the National Guard or active duty military forces to suppress an insurrection, which is very, very loosely defined and tends to rely in large part on the word rebellion. And that word rebellion, Donald Trump cited in his executive order, his memorandum that he signed last Saturday night, authorizing the federalization of National Guard troops. So Section 252 of the Insurrection Act is a little more expansive. It allows the military to enforce federal law, not just to suppress an insurrection, but it still does not imply that the military may push aside civilian authorities, which is typically what happens under a declaration of martial law. But again, there is no provision in these code sections that make up the Insurrection Act that allow a president or give him legal authority to declare martial law. Section 253 is the only substantive provision of the Insurrection Act that might on its face be read to authorize a limited form of martial law. Among other things, it allows the president to use National Guard and active duty military to suppress any insurrection, domestic violence, unlawful combination, or conspiracy in a state if it so hinders the execution of state or federal laws that any part or class of the state's residents is deprived of a constitutional right, and the constitutional authorities of the state are unable, fail, or refuse to protect those rights or enforce those laws. The Insurrection Act is an exception to Posse Comitatus, but there are also some circumstances in which the latter law may simply not apply. But Posse Comitatus controls this stuff. And again, this assumes that somebody is going to enforce federal law against the President of the United States. And currently it assumes that there is somebody who is going to enforce federal law against this President of the United States. He is already acting as though he invoked the Insurrection Act without actually having done so in writing or saying that he has invoked the Insurrection Act. He's like, oh, I'm thinking about it. I'm talking about it with people. We're having conversations. I'm talking to the Joint Chiefs and the military. But he has not expressly invoked the Insurrection Act, and that is the only statute under which it is legal to deploy active military troops within the United States for the purposes that Donald Trump is doing so now. Even though we don't specifically know yet what their orders are, but we can surmise. Declarations of martial law are subject to judicial review. So I would have to assume that a president's actions in behaving as though he had invoked or or had behaving as though he had declared martial law, those actions would be reviewable by a court. But the Constitution, federal statutes, and the Supreme Court are clear on one thing. There is nothing in the Constitution or federal statutes or Supreme Court case law or federal court case law that allows or permits or gives power to the President of the United States to declare martial law, to say, I am declaring martial law. However, I fully expect Donald Trump to behave and to conduct himself and to use the United States military as though he did invoke the Insurrection Act and as though he has declared martial law. And as he has shown this so many times before, he will behave in this manner until somebody stops him. And that's been my key question since Inauguration Day when we started learning about all of his plans. Who is going to stop him? Beats the hell out of me. I have no idea. It's not going to be the Senate. It's not going to be the House. It's very likely not going to be the current Supreme Court, and he runs the executive branch. So there we are. Please click like, leave a comment, subscribe to my page. Thank you for watching, and I'll see you guys soon. Please be safe this week.